Can a judgment lien lead to foreclosure? Have you ever wondered how a judgment lien can impact your property and whether it could lead to foreclosure? Let's break it down in simple terms. A judgment lien is a legal claim that a creditor places on your property after winning a court judgment against you for unpaid debts. This lien attaches to your property and can affect your ability to sell or refinance it. Now, whether a judgment lien can lead to foreclosure depends on several factors, including the laws in your state and the type of lien involved. A judgment lien typically attaches to both property you own now and any property you acquire later, within certain time limits. Foreclosure is the legal process that forces the sale of property to satisfy a debt secured by a lien. Judgment liens are usually considered junior liens. This means they are subordinate to prior liens, such as mortgages or property tax liens. When it comes to foreclosure, the priority is determined by the order in which liens were recorded. The rule is simple: first in time, first in right. So, can a judgment lien lead to foreclosure? Yes, it can, but it is less common and more complex than mortgage foreclosure. The lien holder must usually start a judicial foreclosure process. This involves filing a lawsuit to get a court order that allows the sale of the property to pay off the debt. This process is different from the non-judicial foreclosure methods that some mortgage lenders use. Because judgment liens are often junior liens, the money from a foreclosure sale typically goes first to pay off senior liens, like mortgages or property taxes. If the sale proceeds are not enough to cover these senior liens, the judgment lien holder may receive little or nothing. In such cases, they might choose to pursue other collection methods, like wage garnishment or bank levies, instead of foreclosure. Now, let's talk about how bankruptcy affects judgment liens and foreclosure. Filing for bankruptcy does not automatically remove judgment liens from your property. The lien stays attached even if the underlying debt is discharged in bankruptcy. However, bankruptcy does provide a process called lien avoidance. This allows you to remove a judgment lien if it impairs an exemption you are entitled to. This requires a court order during the bankruptcy case. If you successfully avoid the lien, your property becomes free of that judgment lien after the bankruptcy case closes and the discharge is granted. But if the bankruptcy case ends without lien avoidance, the judgment lien remains. The creditor can then foreclose on the property after bankruptcy to satisfy the debt. It is also important to note that bankruptcy protects you from new judgment liens attaching to property you acquire after the bankruptcy discharge. If you are facing a judgment lien and potential foreclosure, filing for bankruptcy can provide relief by either eliminating or avoiding the lien. Consulting with a bankruptcy attorney can help you understand whether lien avoidance is possible and what the timing and impact of bankruptcy on judgment liens will be. Creditors with judgment liens can still pursue foreclosure after bankruptcy, but they need to be aware of the lien's priority and the chances of recovering funds from the sale. In summary, a judgment lien can lead to foreclosure through a judicial process, but due to lien priority and bankruptcy protections, the situation is more complicated than mortgage foreclosure. Understanding these details can help you navigate your options effectively.